It was barely 24 hours for the Supreme Court to commence hearing. The Attorney General wrote to the Chief Justice asking for journalists to be allowed to broadcast proceedings because of the huge public interest in the case, a request the Chief Justice accepted. The courtroom was packed and the huge public interest in the case was obvious. Sponsors of the bill expected that the court would decide on the two injunction applications, potentially paving way for Parliament to try again to serve the President with copies of the bill passed by the House for his assent. But there was an anticlimax. The substance of the injunction application were not even discussed. First, lawyers for Richard Delaskai had two applications.
Notice for an order for leave to amend the release. On our motion or notice for an order of interlocutory injunction, filed on the 7th of March 2024.
Even before the lawyer would conclude his application, Thaddeus Sory, a lawyer for the Speaker of Parliament, was on his feet in opposition.
Yeah, my lords, we have a preliminary point of law to take with regard to this particular application by way of an objection, and that would be the only ground upon which we would be dealing with this application. And yes, my lords, there are two ways. But it's actually
you gave no notice of
it. It is.
You gave no notice of it, did you?
Not by way of a formal application.
There was intense back and forth between Thaddeus Sory and Chief Justice Gertrude Tokono, who presided over the panel.
Sorry.
No, my lady, I've got it right.
You can hear me very well.
Yes, my lady.
You appreciate the pickle we are in.
Yes, my lady.
You filed an affidavit on the 15th of... Please hold on. Don't interrupt me. Please.
Oh, yes, my lady.
Always wait for me to land.
Yeah, I'm not going to say it.
Your substantive application, affidavit before us, is dated the 2nd of April. Listen, let me land. If you had just waited to understand my words instead of rushing to justify yourself, you would have admitted that you didn't have a formal notice to object.
My lady, it's
a lawyer,
yes,
like yourself, like you found yourself muddled up this morning.
Oh,
yes, you have. A lawyer files. I can see what his difficulty is. When you read, you can see he left out some words. You chose to denigrate what happened in his expressions by describing it as muddled and confused. And the man now wants to correct himself by expressing it fully. And you say you have a preliminary legal objection.
Yes, my lady.
Where is the legality?
The legality lies in the fact that the motion paper invokes the jurisdiction of the court. And if there is an irregularity on the face of the motion paper, which I am pointing out as the foundation to which I am not accepting what he has filed.
No, hold on.
Yes.
Which motion paper?
His motion for injunction.
The man is not seeking... Hold on.
Yes.
Whenever I start, stop.
Oh.
You are going to interrupt. I didn't hear what I have to say to you.
Very well, Mali. That once there's an objection taken to it, you cannot overreach that objection with a proposal to amend.
Hold on.
So that's all I'm drawing the court's attention to.
Stop there, Mr. Stop there.
Yes,
stop there. Now, if you had given a formal notice, anyone would have known. But in your affidavit, you only described your opinion.
No, what I found
that's not a preliminary legal objection.
Well, maybe it is not stated that it's stated as an opinion, but what I was stating what I found objectionable about it. And this court has also said that I don't even need that formal notice, that I can get up when he's about to move and take that preliminary objection. Trustees of the Synagogue Church of all nations. And the strain of them from the court that I didn't need.
Mr. Sorry, I'm not impressed by what you're doing.
Very well,
but just finish it.
I'm sorry. So,
finish it.
So I'm saying that
It's not fair to your friend. I don't think so. But you want to do it, do it.
I'm relying on the authorities from this court to take my preliminary objection, that I'm entitled to take it just when it's about to move it.
So just do it.
And my second point is that...
No, what is your first point?
The Attorney General was not opposed to the application of the lawyers. The court unanimously granted the prayer of lawyers for Richard Alaskai and allowed his application.
Our considered view is that the alleged preliminary objection is unnecessary and does not seek to assist any process before this court. Every party has an inherent right to present the appropriate formulation of their reliefs or other process before the court. The objection is dismissed.
As the court pleases, Fali.
You've taken our time and energy for nothing.
Then came the second case against the bill filed by researcher Dr. Amanda Odoi. Lawyers for Dr. Amanda Odoi raised objections against the language employed by Thaddeus Sory, a position the Chief Justice largely agreed with. But Thaddeus Sory says he had a reason for using such language.
It's necessary to say this. Mr. Sory, some of the material in your affidavit is extremely intemperate. I know they are not your affidavit, especially the affidavit of Mary Wendy Yeboah, which you have now withdrawn. Do well not to introduce such material.
I'm most grateful, my lady. Sometimes you respond to what comes from the other side, and that's the reason. But I'm taking cue. When they take a shot at you, you throw something back.
In this case also, the court ruled that Thaddeus Sory withdraws the process and file it again without the language the court described as temperate and inappropriate. Lawyers for Richard Alaskai say they are happy with how proceedings went, expressing support for the decision to allow the broadcast.
Our courts have nothing to hide, especially in this country. These constitutional matters are best placed in public domain so that everybody will hear and understand, to stop some of these speculations we have all around us. It puts an end to this making rounds of stories. We sometimes sound very strange.
Meanwhile, Attorney General and Minister for Justice Godfred Yeboah says the courts must lean more towards allowing the live telecast of such constitutional cases with huge public interest.
If you recall, about 2 years ago, one of my speeches to the Ghana Bar Association actually made a point that indeed, if the media were to have full and unhindered access to proceedings and all, it becomes so clear to the general public that when rulings are given by the court, they're actually on account of principles of law, and indeed most of the rulings of the court are right. I have suffered a lot personally in terms of the misrepresentation of court rulings and deliberate misrepresentation of what I say in court and what I do and all that. So I thought that the best way to avoid any undue misrepresentation of facts is to ensure transparency.
The hope by the Speaker of Parliament and sponsors of the Anti-LGBTQ bill that there would have been conclusion on the injunction applications filed to restrain the Speaker of Parliament in terms of transmitting the bills to the President to sign would have been resolved today, have now been dashed. The court will now have to set a new date to constitute the panel to hear them. But the Speaker of Parliament's lawyers, obviously on the floor, quite pressing so hard to get this case to progress without the need to adjourn. Reporting for Joy News, Kwiku Asante from the Supreme Court here in Accra.